Good morning, ladies and gentlemen. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. First of all, I'd like to welcome you to County Court at Law number 2. You have been asked to come to County Court at Law number 2 because you have a case in this court. The case that you have is classified as a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your more serious type cases, and those cases are handled in the district court. For example, if you have a state jail felony, the range of punishment is anywhere from 6 months to 2 years in the state jail and a fine up to $10,000. If you have a third-degree felony, the range of punishment is minimum 2 years, maximum 10 years, a fine up to $10,000. If you have a second-degree felony, the range of punishment is from 2 to 20 years in the state penitentiary, a fine up to $10,000. If you have a first-degree felony, the range of punishment is 5 to 99 years to life, and a fine up to $10,000. The highest felony is a capital murder. The range of punishment for a capital murder is life or death. Now, those range of punishments are for all of those felony offenses. Now, your case is not a felony offense. You have a misdemeanor offense. Misdemeanors are divided into 3 categories. The first category, which is the lowest category, is a Class C misdemeanor. Class C misdemeanor range of punishment is fine only. You only can get a fine. You cannot get a jail time. Now, your Class C misdemeanors are your cases that you normally hear of in the JP court, which is the justice court, or the city court, which is the municipal court. And for example, the speeding ticket is a Class C misdemeanor, or a seatbelt, not having a seatbelt on, will be a Class C misdemeanor. The next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is 0 days to 180 days in the county jail, which is 6 months, or a fine from $0 to $2,000, or anywhere in between. The next misdemeanor, which is the highest misdemeanor, is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is 0 days to 365 days, which is a year in the county jail, a fine or a fine from $0 to $4,000, or anywhere in between. Now, as I said earlier, the case that you have in this court is classified as a misdemeanor case. Now, the documents that you have in your hand cover a right that you have. Now, you have several rights as a defendant in a criminal case. The first right that I'll go over is your right to have an attorney. The document is titled Judge's Explanation of Rights to Defendants Without Attorney. And it states, as a defendant in a criminal case, you have 3 options regarding getting an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states, defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign your name on the line that says defendant, and you will date it today's date, July 12th of 2022. Does everyone understand? Okay. The next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, only those individuals who will be waiving their right to an attorney and representing themselves will read and sign this document. So if you're not waiving your right to an attorney and representing yourself, you don't have to read and sign this document. Okay, now, for those of you who will be waiving your right for an attorney, then this document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Number 1, it states, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 12th day of July of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that's your choice, for those of you who are waiving your right to an attorney, then you will sign on the line that says defendant, and you will date it today's date, July 12th of 2022. Now, as a defendant in a criminal case, you also have other rights. You have a right to have a trial by jury. What this young lady is sitting in that area over there, we call it the jury box. 6 citizens from Jefferson County will be selected to sit on your case, and they will decide whether or not you're guilty or innocent after listening to all of the evidence. You also have a right to waive or give up your right to have a trial by jury. And by doing so, your case will come before the court in one of 3 ways. One way the case will come before the court is by way of a bench trial. And what a bench trial is, it's a trial before a judge only. You will not have a jury. The judge will listen to the evidence and the judge will decide whether or not you're guilty or not guilty after listening to all of the evidence. Now, your case will also come before the judge by way of a plea bargain. It can come before the judge by way of what we call an agreed plea bargain. And what a plea bargain is, that is an agreement that you have reached with the district attorney's office to settle your case. They call that a plea bargain. They call that an agreed plea bargain. Now, your case will come before the court, and the court will decide whether or not it will follow or not follow the plea bargain agreement. If the court does follow the plea bargain agreement, and you decide later on that you would like to appeal your case, when I say later on, within 30 days that you would like to appeal your case, you have to get permission from the court. Now, if the judge does not go along with the plea bargain agreement, then you will be entitled to withdraw, which means to take back your plea of either guilty or no contest. And the court cannot hold that against you. You have a right to take it back if the court does not go along with the plea bargain that you have reached with the state. The third way that your case will come before the judge is by way of an unagreed plea bargain. Unagreed means that you and the state or the district attorney's office have not been able to reach an agreement to settle your case. However, you still would like your case to come before the judge so the judge could determine what the punishment will be in your case. We call that an unagreed plea bargain, okay? So just to recap, you have a right to have a trial by jury. You have a right to waive it, which means you have a right to give it up. And if you do so, your case can come before the judge by way of a bench trial, by way of an agreed plea bargain, or by way of an unagreed plea bargain. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. That area over there, we call that the witness stand. And what witnesses do, they will come to court and they can testify. They can testify for you or against you. You can ask them questions. We call that either direct examination or cross-examination. Now, if you're representing yourself, you will be entitled to ask the questions. Now, if you're represented by an attorney, your attorney will be entitled to ask the questions. Now, you also have a right to waive or give up your right to have witnesses to come to court, which means you have a right not to call any witnesses in your case. Now, just because you do not call any witnesses does not mean the state will not call witnesses. The state will call witnesses in the case that they have against you. You have a right against self-incrimination. Self-incrimination means that you have a right not to testify yourself in your case. We call that the Fifth Amendment right against self-incrimination. Now, you have a right to waive or give up that right as well. Now, if you waive or give up your Fifth Amendment right against self-incrimination, that means that you will be testifying in your case. Now, if you do not waive your right to testify, the state cannot force you to testify if you invoke your Fifth Amendment right against self-incrimination. All right, so you cannot be forced to testify in your case. Also, you have a right to have discovery. Discovery means that you have a right to see the evidence that the state has against you in your case. We call that discovery. Now, you also have a right to waive or give up your right to have discovery, which means you have a right not to see the evidence that the state has in your case. Now, when I say you have a right to have discovery, that means you will have access to the evidence, to the documents, to the witness statements, to videos, to instruments, whatever the state has as evidence in your case, you have a right to have access to it. If you're represented by an attorney, your attorney will have the right on your behalf to have access to the evidence. Now, as a defendant in a criminal case, first of all, each and every one of you that's here today, you've been arrested and you're out on bond. You're either out on what we call a personal recognizance bond, commonly referred to as a PR bond, or you're out on a cash bond, which means you paid the full amount to get out, or you're out on a surety bond, which means that you have a bondsman that you pay so that you can get out of jail. Now, every day that you have spent in jail can be used as credit towards your case. So, for example, let's say you spent, you're in the state, well, let's say you spent 5 days in jail, and let's say you're in the state has come to a plea bargain agreement, and that agreement is that you will serve 5 days in jail. What that means is you will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you will be given credit for time served. Now, if they're offering more than the 5 days that you serve, for example, if they're offering 7 days in jail, you serve 5, that means you have to serve 2 more days in jail. Not the 7, but you have to serve 2 days because you've already served 5. The other thing is, if the state is offering you a fine and court costs, now you should be aware that every day that you spent in jail is credited as $100 per day that will go toward, that can go toward your fine and court costs. And what that basically means is, if you served 5 days in jail, That's $500 that can go toward your fine and court costs. So if the state is offering you 5 days in jail, you've already served 5 days in jail. If they offer you fine and court costs of $500, you would not have to pay it because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if they are offering fine and court costs of $700, that simply means that you'd have to pay $200. Now, if you cannot pay the $200, then the court can allow you to be placed on what is called a payment plan, which means that you could pay it off in installments, in monthly installments. Now, you may not have money to pay off the installments. If you cannot pay off the installments, then the court can convert your fine and court costs to community service. Now, that simply means you would have to work off your fine and court costs. Now, every hour that you do on community service, you get $12.50 that will go toward your fine and court costs. So if you work if you do 8 hours of community service in one day, that's $100. Okay. So the community service, as I said earlier, can be where your fine and court costs can be converted to community service. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. You get into the program, they will dismiss your case, and you can get an expunge from your record. Expunge means wiped off, deleted, or erased from your criminal record. Now, in order to get into the program, you have to have an attorney to submit the application. You also, it has to be your first offense. You cannot have a criminal history, and it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. If you are a veteran of any one of the branches of the United States military, Jefferson County DA's office has a program that is called Veterans Court. Veterans Court is also part of the pretrial diversion program. And with that program, you get into the program, and once you complete the program, case is dismissed, you can get it expunged from your record. I think the only criteria for getting into the program is just you have to be a veteran of any one of the branches of the United States military. Also, this court has a program that is called the CSI program. That's a program that I started in March of 2017, over 5 years ago. And with that program was started within the first 100 days of taking office. And that program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. And the way the program works is address the issue of recidivism. Recidivism means that people commit crimes over and over. And so how do we address it? Well, we address it through our CSI program, which is Community Safety Initiative. We have a partnership with local agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop Center is our local mental health center. We have some people here from Spindletop, and one of those individuals will come up and tell you a little bit about the program in a little bit. Now, Spindletop will be able to do in a private interview, an assessment, and they could develop a treatment plan either for outpatient, inpatient treatment. Now, you do not have to be insane or incompetent to participate in the program. If you suffer from any type of mental illness, for example, anxiety, depression, post-traumatic stress, it could be paranoid schizophrenia, depression, just a whole host of other ADD, a whole host of other mental illnesses that an individual may have, even if a person is what we call have IDD, intellectual disability. If a person is intellectually disabled, Spindletop could address those issues as well. And so with that, you do not have to be insane, you do not have to be incompetent. Only thing you have to do is have a desire. You have some mental issues that they can address. They'll be happy to address those issues for you. The other thing is, Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery Program. It is a program that deals with drugs and alcohol abuse. Now, we also can refer individuals to the Alcohol Drug Abuse Council that has a program called Outreach, Screening, Assessment, and Referrals, and it's commonly known as OZO. With those programs, they will do a screening, an assessment, and then you could be referred to outpatient, either outpatient or inpatient services to address your drug or alcohol abuse issues. If you do not have a job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in one of those areas that you select, then they will assist you at getting a job in the area that you are trained in. Also, if you have not graduated from high school and you would like to get your GED, the CICE program has a GED program that can assist you at getting your GED. Now, all of these programs that I just talked to you about are absolutely free, does not cost you anything. The only thing you have to do is have a desire to be in the program. In County Court at Law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we are making a difference. We're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference in Jefferson County, the community in which we live, by making Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. County Court at Law number 2, we do not just arrest the problem, we address the problem. We do not just give time, we take our time. And we're in County Court at Law number 2, we're trying to make productive people. And we believe that we can make productive people, then productive people will not commit crimes because they have too much to lose. So if you're interested in the programs, just let us know, and we'll be happy to give you the information that you need to get into the program. Now, at this time, we have Deputy Hinton, who is with Spindletop, and Deputy Hinton is going to come forward and tell you a little bit about what Spindletop has to offer. Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. I'm here with my partner, Sarah. Sarah is a qualified mental health professional with Spindletop. The reason we're here this morning is because the judge cares about every single person that comes before his bench. What the judge has found is people who appear with legal issues before him commonly have mental health or substance use disorders, or just lack connection with community resources to help them with their particular situation. Now, this may be your first time to be here, maybe your 10th time to be here. There's hope for you. In fact, Spindletop has a system that we can plug you in to get you the community resources that best benefit you. You see a value in this. We don't know this until we visit with you. So there's a demographic form that you're going to fill out, and we'll just put that information that you're looking for. That information is private. We will only share that with your permission, but we're looking to find ways to help you in your particular situation. Now, maybe this doesn't apply to you. Maybe it applies to a family member. We'll still be glad to work through you for that family member and advocate for them as well and getting them connected to community resources. At the very least, I want to give you this flyer. On the back side, it tells you a little bit about what we do and why we're here. Also, on the front side, there's a 1-800 number. It's a crisis hotline number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. I'm gonna get this in everybody's hand. Again, if this doesn't apply to you, you can take this to your family member or your friend that you believe would benefit from it, and they can communicate with us, and we'd be glad to work with them as well. Does anybody have any questions? When the court goes into recess, we're gonna be visiting with everyone. So I'm gonna ask you to do something. It may be a little bit uncomfortable. I'm gonna ask you to share your need with Sarah or I so that we can help you. The judge will give us an opportunity to go to the jury room. It's private, no one else will hear, and we can speak specifically about your situation and help you. If you don't feel comfortable talking here in the court setting, I understand that. We will call you if you'll provide that phone number for us, and we will contact you later this week to try to do the same thing that we would do here in a more private setting for you, whatever's convenient for you and however we can help you. That's our goal, and that's our objective today. Thank you for listening. Thank you.
Okay, thank you, Deputy. Okay, ladies and gentlemen, the clipboards that you have, that paperwork on there, we're gonna have our court personnel come and collect that from you. And then it's gonna take us a few minutes to go through the paperwork. And then what we're going to do, we're gonna call you up before the bench, one at a time. And then once we call you up to the bench and your case is disposed of, you'll be free to go and you have a blessed day. Now, the other thing is, if you need to use the restroom or anything like that, if you go outside this door that I'm pointing at, you turn to your right, the men's restroom is on this side of the hallway. The women's restroom is on the other side of the hallway, okay? So we're gonna be in recess, and if you need any help, just let us know, and we'll have someone from our court personnel that will be able to assist you with filling out the applications. Now, for those individuals who will be applying for a court-appointed attorney, we have a form that is called an affidavit of indigence, and that form, you will be required to fill it out completely. So I think it's maybe a 2-page form. Your information, I think, is on page 1 and page 2. It's going to have information regarding for example, your name, your address, whether or not you receive or do not receive any governmental beneficiaries. It also have information on there about whether or not you have any children, whether or not you're married, living information like if you own a home, rent a home, live with someone, or do not have a home. And also it have your income. Now the income, they're talking about what you make per month if you are working. If you're not working, then it'd just be zero. So you have to put something in each one of the columns, is what I'm saying. If it's zero, you just put zero if you don't have anything there. Now, if you don't have any of those benefits, you don't need to check them off. And then it comes with your expenses. Now your expenses is going to talk about, if you have to pay a rent, mortgage, whether or not you have a food bill, whether you have utilities. Now, when you get to the part about transportation, make sure to include not only if you're paying a car note, but also insurance, and also what you're paying, what you estimate you're paying on gas. So you total that up, because a lot of times people think transportation, they think, oh, they're talking about gas, but no, insurance, if you gotta pay insurance, a car note if you're still paying a car note, and what your gas bill is per month. All of that stuff is per month. Okay. Now, if you don't have anything, just put a zero and just go down, and at the bottom of those, I think it totals. And then on the second page, it has up in the left-hand side at the top, it has a spot that says defender signature. That's where you will sign. And then I think you would fill out the bottom that talks about the unsworn affidavit. Okay. So at this time, the court is going to be in recess to give you an opportunity for the court to pick up the paperwork from you. At this time, the court will be in recess.